Now closed, we have our two streams here. I'd like to introduce our first speaker, who's Sam De Silva. Sam is a commercial lawyer. He's chair of the British Computer Society's Law Committee, and he's a partner of the law firm CMS. And I can also say he was recently interviewed on Newsnight by Victoria Derbyshire. Sam's going to speak to us about the law relating to computer-generated evidence and the relevance to software testing. So I'd like to hand over to Sam now. Thank you.
Well, I thought there might be a risk that I'll be speaking to no one, as when Mike said that's the number, but yeah, clearly that's not the case. So as Mike mentioned, I'm a commercial solicitor, partner specialising in technology law. Delighted to come to speak to your group. I think I've spoken at your conference a few times before. So great to see you all turn up. So as Mike said, I'm going to talk about computer generated evidence, and there's a bit of a change, and I'm going to talk about the role of experts in court proceedings. So I think that's going to be quite relevant, particularly given next week when we see Gareth Jenkins, who's the Fujitsu expert, who's going to be 4 days and things. So you as software testers may be called as an expert or asked to be an expert. So I think it's useful for you to know what that entails, rather than you being called upon an inquiry, which is probably not a very comfortable position. So what am I going to talk about?
Just use the mouse.
Yeah. Okay, fine. Okay, fine. Can you see the slides? Okay. Yeah. Okay. Fine. So I'm going to talk about the common law position, and then I'm going to talk about Section 69 of the Police and Criminal Evidence Act, or known as PACE. Then talk about the Law Commission report and the repeal of Section 69. Then talk about the way forward, and then talk about different types of experts and stuff. Fine. So at the beginning, we've got the common law position. So when lawyers refer to the common law position, what we mean by that is basically in common law jurisdictions such as England, New Zealand, Australia, the common law is effectively case made law, i.e. there's no specific legislation, it's all determined by cases. So the common law position right at the beginning is set out there in terms of computer generated evidence. I'll give you a 30 seconds or so to read that. You can obviously see the common law position was determined before computers were actually there, because it talks about mechanical instruments. So what this means in a nutshell is if the prosecution wanted to bring a case and the evidence was generated by a computer, it could do so, and then that would be presumed to be the evidence, or the data generated would be presumed to be reliable or accurate, unless the defense can claim that the computer was not operating properly. So the assumption was that all computers operate correctly, yeah? And we all know that is completely. So that was the common law position, but because of various issues in terms of, I guess, direct evidence and hearsay. So what I mean by direct evidence is if a computer generates a report or data, that evidence could be held as direct evidence and it was admissible. But there's a problem with that, because there's a concept of hearsay, yeah? So hearsay means that effectively, if a document or data was produced by a computer, if there wasn't a person who could actually sort of substantiate that data, that evidence would be inadmissible because of hearsay. So there was an inherent conflict with the common law position, direct evidence, and rules of evidence. So it was a bit of a mess, yeah? So that's why in 1984, this section was introduced under the PACE Act, Section 69. Again, I'll give you 30 seconds or so to read that. So what that did was actually reverse the presumption. So remember the common law position, computers operated correctly. This actually reversed the presumption, which effectively said if the prosecution bought computer generated evidence, it would actually have to prove that the computer was operating properly. So the actual onus was on the prosecution as opposed to the defense. And that seemed like a perfectly, reasonable position. But unfortunately, in 1997, the Law Commission actually recommended that Section 69 would be repealed, and we go back to the common law position. And the reasons that they set out was 5 reasons. First one, that they failed to address the major causes of inaccuracy in computer evidence. Advances in computer technology made it difficult to comply with 69. So what this meant was, Section 69 meant that if the prosecution had to bring sort of cases and it relied on computer evidence, every time it would have to prove that the system was operating accurately, and then there was criticism that was quite burdensome on the court, on the prosecution. Reason 3, I'm not sure why that was a reason. Effectively, we would say the prosecution would have to do the work as opposed to the defense. You could argue, well, if the prosecution was a large organization, they probably got better resources than smaller organizations. Then they basically said reason 4, it was illogical to apply, because sometimes if an expert, and we'll talk about experts, relied on computer generated evidence, they could actually rely on that, so they didn't actually have to prove that the computer was operating accurately. So there was a bit of a gap there, and then there was problems with interpretation of Section 69. Variety of cases, which I won't go into detail, which some cases held that the computer generated evidence was admissible, some held that they weren't, and so forth. So there was a number of problems that the Law Commission sought to repeal Section 69. Unfortunately, reasons 1 and 3, which we go back, were actually based on a misinterpretation on a paper by Professor Colin Tapper. People know who Colin Tapper was. He's quite a forefront of sort of legal technology and so forth. So they relied on a paper he wrote, but they actually misinterpreted it. So Section 69 was repealed and it wasn't in place. So the common law position applies again. That was done in the Youth, Justice and Criminal Evidence Act. So now we're back to the common law position, yeah? And I won't go too much about what the consequences of are, but I'm sure unless you were hiding your head in the sand, you'll know what that meant. So I think a better way forward is, I don't think putting back Section 69 is going to be the solution. I think a sort of a compromise position would be this process here. And, I'm not taking any credit for it. This was proposed by a couple of barristers, technical people and solicitors in that paper, and I recommend you read it. And what they've proposed is a 2-stage process. So in the first stage, basically the parties need to actually gather evidence of various things. For example, they need to know about the known sort of in the system before they present the evidence. They need to prove that there's records of the known errors. Then they need to have a description of the various information security policies and other relevant sort of standards and processes used in sort of deploying that technology. There need to be reports of audits. They need to show that the errors were properly managed. They need to actually confirm that they actually did their proper search for all this stuff. They can't just say, yeah, we've searched it, we can't find any errors. You actually have to do a proper search, and they need to give assurance that reasonable steps have taken. So that's stage 1. So if that was satisfied, then the computer evidence would be admissible. But if they couldn't satisfy stage 1, what the proposal is a more detailed examination has to be undertaken. So need to show that, the system may not be adequately managed. the number of bugs is sufficiently high to sort of question the reliability of the system, and it identifies specific errors that provide grounds for questioning evidence. So again, if that is satisfied, then the computer evidence could be admissible. If not, it can't be. So you can see those two stages is actually gives a bit more, I guess, assurance that the actual evidence or data generated from the computer is actually reliable and can be relied on prosecutions. And we've at the BCS have been sort of promoting for that kind of change in the law, i.e. the common law position is not fit for purpose. So therefore another approach needs to be undertaken. So that's a fairly helicopter view of, the law of computer generated evidence. It can be quite complex. So I'll try to simplify it as much as possible. So before I go to the next session, any questions on that? Okay. Free legal advice. That always. Okay. Yeah.
So you said in the common law,
Yeah.
it's assumed that the jury is reliable unless sort of proven up. Does that ever happen? Do people ever put forward an argument?
Yeah, no, well, I mean, I didn't want to mention this because I think everybody's probably post office, but that's what happened in the post office case when the postmasters brought that case. Sorry. It was proven that the system had known error logs and it was unreliable, and that's why the evidence, that's why all the convictions got reversed, and all the people who unfortunately went to jail have gone to jail. So it is done, but the problem is that is a lot of onus on the defence. Yeah.
Excuse me.
Yeah.
So what accountability is there for like project managers and software testers be getting pulled up to be questioned about the sort of failure of that system?
Potentially, and we'll talk about that in the next stage in terms of expert advisors and expert witnesses. Yeah, but yeah, potentially.
All pretty long gone, haven't they? The people who tested that are probably all long gone.
Yeah. Well, apart from a few who are coming in front of the inquiry. So yeah.
And we're probably seeing more of that with AI, with the regulations and standards coming in. So it's a route we're going to go down in the future, I think.
Yeah. Well, I mean, with AI, it's going to be even more difficult because, it's not necessarily the software programs that may know how there's any bugs. It could be the AI itself that creates the issues. Okay, so then we go on to the different types of experts. So I think experts are used quite loosely, but there are actually two sort of different concepts. There's the expert witness and the expert advisor, and experts are used collectively to sort of describe both terms, but they're quite different roles. So an expert witness is a person who's been instructed by an organization or another person to give evidence in relation to the proceedings. It's in relation to technical or scientific nature. It's based on opinion rather than the fact, i.e., based on the opinion of the expert. The assumption is that it'll be given in a written form, although, it can be given verbally. You need to get permission. The important thing is the primary duty is to help the court. Yeah. So what that means is even if as an expert witness, you've been engaged or appointed by your employer, your duty is to the court, i.e. it's not to the person who is actually paying you to come for, and that's really important to note. So that's the expert witness. The expert advisor, that's an independent expert. Again, advises on specialist technical matters, and it can be at any stage of a dispute or claim. So they could support with evaluating and formulating the case, preparing witness statements and other things. Often expert advisors are appointed even before it becomes a court proceedings, and they may say, look, there's no point going to court on this. You're effectively going to lose. There's going to go lots of money is going to be lost. So we recommend that you don't actually you settle, for example. So it's actually can be involved at different stages. So it is possible to transition from an expert advisor to an expert witness, but the thing that you need to remember is if you're an expert witness, your duty is to the court. Yeah, it's not you're not independent in the sense that you're not. Well, you are independent. You're not representing the party that's appointed you, which seems a bit unusual, but that is what it is. And so the emphasis is it's not. You're not just giving opinions on the arguments that support your own case side, but you also need to give opinions on the opposing side's arguments. So if you think the opposing side's arguments are valid and credible, you actually need to give your opinion. Yeah, that is correct, which, you seem strange. Well, you're appointed by a certain party. Why are you sort of supporting another party? But that is how it works. So that's just something you need to be really careful about when someone comes to you and go, we want you to be an expert. I think you need to ask them, well, is it as an expert advisor or is it as an expert witness? Because it is quite different in terms of the obligations and responsibilities. And also, I think you need to ask, whoever's instructing you, the solicitor or barrister, what are my rules? What are my duties? Because that's not your day job to know, what you're permitted to do and not do. And so it should be the solicitor or instructing barrister that actually tells you, what you're permitted to do and what you're not permitted to do. And if you do doubt it, I would always recommend getting a second opinion. Yeah, you can't just say the lawyer told me to do this or so forth. Yeah. So that's it. I know it's a bit of a helicopter thing. I think got some time for 5 minutes for questions.
Yes,
Yeah.
yes. Anyone got any questions for Sam about law and how it might apply to us and being a witness or in court or projects that you've worked on or the post office if we're not bored by the.
Is there a clear distinction between a bug or an error or a fault in the system or a system that's actually, call it bug free, but it's misused or misappropriated in how it's used and the evidence it's generated by the computer is wrong? For example, lots of people logging in using the same ID, their masks, actually logged in to balance on an account, for example.
Yeah. So in that case, you could argue the system was operating properly because it wasn't the bugs, it was the actual processes. Yeah. So I think that will need to be taken into account as well. So it's not just simply saying, yeah, the system has not got any bugs or is operating according to the specifications, but as you say, it's a processes around it, of course, the issue. Yeah, that will need to be taken into consideration. Other questions? Yeah.
So obviously in the post office case, there is no case in terms of the software side of things. Is there like another example where it was a bit more grey in terms of like the software versus the defense, I guess?
I think there have been other cases where, it wasn't so stark that it was the system that was, at fault. But I think in those cases, I think the process came into play as well. So yeah, you're right. Sometimes it's not as clear as the system is completely not operating. It could be, it could well be that the system is actually got bugs, but those bugs don't actually affect the evidence. So it could be some other aspect of the system, yeah, which is totally not connected to the actual evidence generated, in which case, it's unreasonable to say, well, the whole evidence needs to be chucked out because, the evidence generated by that system didn't have any errors, is something else that had errors. But then you could argue, well, are those errors indicative that there's an underlying problem? Yeah, so it does get a bit murky, challenging.
The first amendment was 1997.
Yeah.
Do you think we will be ready for AI actually? In terms of
No, and I'm saying no because the AI Act don't know if you've been following it. It's obviously, enforced, but there'll be a transition period. The AI Act is quite high level. All the detail is going to be in standards, in various standards. Those standards are being developed and they need to be developed by April 2025. I don't, as you know, ISO standards take 3 to 4 years. So getting all those standards in place by April 2025 is going to be pretty challenging. So I think the difficulty is you'll have a piece of legislation with high level requirements, but all the detail and preciseness, there won't be much guidance because that's all where the standards are provided. So my feeling is I think that they will realize that the standards won't be in place by the time they think it will, and they may say, well, we'll extend the transition period till the standards come into play. That's my feeling. I've got no inside sort of knowledge on that, but yeah, otherwise I think it's not going to help businesses because they'll go, okay, we know what the high level requirements are, but what does that actually mean in practice? In terms of what, computer generated evidence or just generally law? I think, that two-stage process probably is obviously developed before AI, so it needs to be thought through how that will apply. Again, I think law unfortunately doesn't keep up with technology. So, you want to be in a situation where the law is agile enough to actually keep up with, what's happening. Yeah. But I think, there is in the AI Act, there are sort of prohibited AI systems, i.e., AI systems used to, make judicial decisions. They are prohibited. So there is some protections available. Yeah.
Sort of related.
Sorry.
Related to that.
Yeah.
When you think there's going to be a change in the common law position, or anytime soon, or
hopefully. Well, I'm hoping. I think a lot of people are hoping after the inquiry makes this sort of decisions, that might be a trigger. Hopefully, they will mention that this is an issue. But there have been commentators who have been talking about a change to the common law position for a number of years, but nothing's really been done, unfortunately. Hopefully this is the trigger for that.
The onus of the defence having to prove that the system was faulty, how does that work in the case when software is proprietary and it's a black box? All you can do is observe its external behaviour and say there's something not right. You have no insight into proving a fault.
Yeah, well, you can, if it's court proceeding, you can apply for disclosure. You can apply for disclosure, and the prosecution will have to give that details. But there's been certain cases which I won't mention where the prosecution weren't so forthcoming in the disclosure. But again, that is a problem. Yeah, you're right. The defence will need the information which they're not in control of. That's by the
case preparation.
Correct. Yeah.
Presumably that gets even harder for AI systems with a sort of low level of explainability, because you may have to disclose the prosecution and may have to disclose how the system works, but they may not actually understand how the system works. So how do you overcome that?
Well, I think, one option is not to rely on evidence generated by AI system, because it's so murky. Yeah. Otherwise you get to, you get a place where, you may have, inadvertent results. Yeah.
Also, what I mean, if a system that's been created, or an AI system is necessarily for evidence, but it's being used to commit a crime.
Yeah.
How again do you sort of go in and how can you prove that it's not working as intended if no one actually understands how it works?
Yeah, I guess it's all about the collaborating evidence rather than just relying on that one piece of evidence. Yeah. Whereas, in some cases, the computer was basically the only evidence that was relied on, but there'll be other collaborating evidence which hopefully should be used to support that argument. I think we're done, aren't we? Yeah.
I'll say thank you very much for a fantastic presentation, Sam. And thank you for great questions, because it shows what a thought-provoking presentation it was. And we're actually finishing bang on time as well, so that's particularly good as well. So thank you, everybody, and a round of applause. you.